Hello and welcome to this extra special video recap of week 2 of the historic Trump trial. Let's just dive right in. We got a lot to cover, shall we? If you're looking for a backgrounder on this trial, check out my video last week where I went through the history and central questions in this case and went over week 1. For legal reasons, everything I'm about to say is alleged, okay? Great. So last week, a jury selection that was expected to last 2 weeks ended up lasting just 1 week, with 5 women and 7 men from Manhattan impaneled, sworn in, and ready to fucking go, okay? And at the end of the day on Friday, that's where they left it. But as the day was ending on Friday, a man lit himself on fire in the park across the street from the trial. And just an update on that, that man, 𝗪𝗧𝗪𝗧𝗪, was pronounced dead later that evening. It's unclear what his political affiliation exactly was. He had been acting erratically for quite some time prior to the incident. He exhibited paranoia and concerned his friends and neighbors. So what at first seemed like maybe was a protest or something by a Trump supporter turned out to just be kind of a tragic end for a man who seems to have been unwell for a while. And that incident kind of cast a shadow over the end of a week of jury selection in what is the first criminal trial of a U.S. president in history. So then Monday morning rolled around and we were ready to undergo week 2 of this historic trial. Monday morning, 9 a.m., trial was back in session. First, if you'll recall, the court held a Sandoval hearing to determine what evidence, if any, the judge would allow in should Trump decide to take the stand in his own defense. That hearing happened last week, and Judge 𝗪𝗧𝗛 made his ruling on Monday morning, saying that he would allow Trump to be cross-examined on the verdict in the New York civil fraud case brought by Attorney General Leeja James that found that he violated the law by fraudulently inflating the value of his properties. That can come into evidence if he testifies. Prosecutors will also be allowed to ask Trump about the 2 violations of the gag order during that trial. They'll also be allowed to ask Trump about both E. Jean Carroll verdicts in federal court, where juries found that Trump defamed Carroll by denying her allegations that he assaulted her. And the judge will also allow prosecutors to reference testimony from Trump about the settlement he reached with the New York Attorney General that led to the dissolution of the Donald J. Trump Foundation. Now, it wasn't completely all in the prosecution's favor. The judge won't allow prosecutors to ask Trump about the ruling in Florida that sanctioned him for filing a frivolous lawsuit against Hillary Clinton. Or the 2022 Trump org tax fraud conviction. That's also off limits. So should Trump take the stand, which he's insisted he will, a lot of the other cases against him will be on the table for the prosecutors to question his credibility and cross-examine him. So Monday morning, after the judge issued this ruling on the Sandoval hearing, the jury was brought in and given instructions by the judge. They were reminded to be fair and impartial, that the defendant is innocent until proven guilty, and that the burden of proof is on the prosecution to prove the accusations beyond a reasonable doubt. Then we turned to opening arguments. So the prosecution started. They laid out their case against Trump, framing the case for jurors as illegal payments to try to illicitly influence the 2016 election that Trump then tried to illegally cover up by falsifying business records. And central to their argument is a scheme between Trump, Michael Cohen, his former fixer, and David Pecker, the former CEO of American Media, the parent company of the National Enquirer. In that scheme, the National Enquirer agreed to publish stories favorable to Trump, publish stories negative about his political rivals, and catch and kill any stories that may put Trump in a bad light, especially with regards to women. And this means that the National Enquirer agreed to buy the rights to these stories and then never publish them, and would then theoretically be reimbursed by Trump. And they did this with a man who claimed that Trump had fathered an illegitimate child, which turned out to be untrue. They did it with Karen McDougal, a Playboy model who claimed to have an affair with Trump. And then there's also the hush money payments to Stormy Daniels, which the National Enquirer was involved with, though they did not actually do the payment. The payment happened from Michael Cohen. Michael Cohen was then reimbursed, and those reimbursements were labeled legal fees in the official business records in an attempt to cover up the underlying election interference scheme. And key to this is that Trump intended to interfere with the election through these actions and then intended to cover it up with the misleading labeling of the legal fees. The prosecution made clear that this was his intention. And that's really key to this case. They have to prove that he knew it and it was his intention. It's not about covering up one story to save embarrassment or to save his family. It's part of a scheme to illegally influence an election, and Trump was at the head of that scheme, according to the prosecution. They also brought up their star witness, Michael Cohen, and assured the jury that he was telling the truth about Trump and that his testimony would be corroborated so that the jury would believe beyond a reasonable doubt that Trump is guilty. Now, for their part, the defense began opening statements by declaring Trump's innocence. The defense attorney was careful to call Trump President Trump over and over again in what I assume is an attempt to remind jurors of the special, powerful position that the defendant holds, lest they forget, and treat him like some lowly, common criminal, okay? And the defense's strategy appears to be simply to poke holes in the prosecution's argument, which is all they really need to do. They just need to introduce doubt in the minds of at least one juror, and then there's no conviction. And sometimes a defense team will present an alternate theory of the case or an alternate story, some argument that shows jurors their side, the defense's side of the story, but that doesn't seem to be the case here, and they don't have to do that. They just have to poke holes. The defense especially leaned into Michael Cohen's past perjury convictions and claimed that he was a man obsessed with Trump and simply seeking revenge for past grievances. The defense also argued that even if a paper trail does exist of these business records, Trump wasn't involved in any cover-up and nothing illegal had happened. Cohen was a lawyer, so his costs were legal fees. Paying someone hush money isn't technically illegal. Trying to influence the outcome of an election is just politics, baby. Basically, none of this is a big deal, and the prosecution is making it seem like a bigger deal than it is. This is all just run-of-the-mill stuff, okay? But of course, as many legal analysts are saying, this is a big deal. Context here is crucial. It's everything. This isn't just another simple white-collar crime of falsifying business records. This isn't just someone getting paid to sign an NDA. This is a person running to be the president of the United States and reaching an agreement with a major publication to systematically cover up material information on the days and weeks leading up to the election to ensure that it never reaches the public, with the intent, at least according to the prosecution, to change the outcome of that election. This is not your run-of-the-mill falsifying business records case, and this is not your run-of-the-mill defendant, and that context is important. And this touches on a larger point, one that Trump is always whining about, and that this is a political circus and that he's being unfairly picked on. And while, yes, I believe that defendants are innocent until proven guilty, and this jury should apply the law to the facts of this case as objectively as humanly possible, questionable how objective is humanly possible, but they should. But this is a situation that does warrant scrutiny. This isn't Joe Schmo, the businessman, falsifying a business record or lying to the IRS or doing any other run-of-the-mill white-collar crime. This is a person who put himself out as a major public figure and who should, frankly, be scrutinized because of it. He should be held to the same standards as everyone else, but the reality is that his actions are going to be more scrutinized than the average person. A lot of white-collar crime, frankly, probably most of it, goes unprosecuted in this country. It's really easy to get away with some gentle tax evasion, okay, or a little lie in the business records or a tiny bit of insider trading, okay? Happens a lot. Doesn't get prosecuted. But if you're doing those things and are also the future or former president of the United States, yeah, we're going to be looking more carefully at your actions than the average person. It's going to be a little harder to get away with shit, as it should be. So if it is true that he's broken the law in this situation and he's getting caught, that's not a witch hunt. That's the people of this country properly scrutinizing the actions of its elected officials and the people wielding the greatest political power. And I'm okay with that. All right. So after claiming his innocence and downplaying the whole situation, reminding jurors that Michael Cohen isn't trustworthy, the defense ended its opening statements, and it was the prosecution's turn to call its first witness Monday afternoon. They called David Pecker, former CEO of American Media, the former parent company of the National Enquirer. David Pecker was given immunity from prosecution in this case in exchange for agreeing to be a witness. On Monday, they only got through about half an hour of questioning, which does not get you far in these trials. The prosecution first has to establish for the jury who this person is and why he matters. So they just asked him about himself and his professional history, as well as his role as CEO of American media. And court then wrapped for the day before they could get very far with the questioning. So then Tuesday morning comes around. It starts with a brief hearing over Trump's alleged violations of the gag order put in place to keep him from, running his damn mouth like he likes to do. The prosecution presented evidence of Trump's violation of the gag order, and when Trump's attorney tried to argue that Trump was just trying really hard to be very careful with complying with the gag order, Judge 𝗪𝗠 told Trump's attorney that he was losing all credibility, which is not something you'll want to hear from a judge. So the prosecution argued that Trump should be held in contempt for violating the gag order, which could come with fines or jail time, though the prosecution is just seeking a fine for now. And the judge reserved his judgment for now, but made it clear he was not impressed with Trump's team's arguments. So we're still waiting to get a decision on that. And after the hearing was held, the jury was brought back in to continue hearing testimony from the prosecution's first witness, David Pecker. And on the stand on Tuesday, Pecker's testimony revolved around a meeting that happened in August 2015 at Trump Tower between Trump, Pecker, and Michael Cohen, and established the catch and kill scheme that's at the center of the prosecution's argument. So Pecker testified that he's known Trump since the 80s and has had a great relationship with him, but began seeing him much more frequently after he announced his 2016 presidential bid. And at that August 2015 meeting, Pecker testified that he agreed to be Trump's eyes and ears, seeking out negative stories, especially from women, to either buy and kill or have someone else pay them off. And the agreement, however, was never put into writing, according to David Pecker. He claimed to be in regular contact with Cohen. If he heard any negative stories about Trump or his family, Cohen requested that he run negative stories about Trump's political opponents, and he would send articles to Cohen before they were ever published, so they were in constant contact. Pecker witnessed Trump's business practices while being a part of his inner circle, and he classified Trump as a micromanager who frequently overviewed invoices, which is an important point. If Trump's defense is to claim that he had nothing to do with the payments or the business records, but people are claiming that he was a micromanager who oversaw all of these details, those two don't line up, Pecker also testified about paying off a man who claimed Trump had fathered an illegitimate child, even though Pecker knew it was probably false. And Pecker testified that he paid this man off because he was concerned that the story would be damaging to Trump's campaign. He also testified about the National Enquirer interview with Karen McDougal, who claimed to have a relationship with Trump. Pecker said Cohen called him repeatedly about the interview to check in on how it went. And that's as far as they got on Tuesday. Court wrapped after he had been testifying for about 2 hours, wrapped a little bit early. Wednesday rolls around, no court Wednesday, so we're already into Thursday, okay? Before we get, however, into the ongoing hush money trial and what happened on Thursday, there's another important update to note that also happened on Thursday. There were Supreme Court oral arguments heard on Thursday related to presidential immunity. It's an appeal from the case against Trump, not this one, the other one of the other ones, brought against him by Jack Smith, special prosecutor, or as I like to call him, Daddy Jack Smith, which is related to January 6th and criminal prosecution against Trump for obstructing democracy and the transfer of power. In that case, the D.C. Circuit Court unanimously ruled that Trump had no immunity and that a president has no immunity in criminal matters. And the Supreme Court agreed to hear Trump's appeal on that case. And the Supreme Court's decision in this could have wide-ranging effects now for Trump, but also for future presidents. So in this case, the defense argues that that immunity, presidential immunity, has been found in civil cases and should spread to criminal cases because a president shouldn't have to fear retaliation for the things they do while in office. While the prosecution, aka Daddy Jack Smith, argued that no one is above the law, the president is tasked with enforcing the Constitution, so he should also be held to the rule of the Constitution. And basically, it comes down to a question of which situation is worse. A world in which presidents have no protections against prosecution and are ceaselessly pursued in the courts by their rivals in a never-ending cycle of political retribution, or a world where we allow presidents to be unbounded by criminal law and permitted to do whatever they want with impunity. For example, I don't know, going on Fifth Avenue and shooting someone without getting punished. That's the question before the Supreme Court. They heard oral arguments on Thursday, but they won't be making a ruling until June or July, just because that's how their schedule works. Analysts are saying that the conservative majority seems inclined to find that presidents do, at least in some cases, have immunity, which would send the case back down to the lower courts to determine how that affects their rulings in this Trump case, meaning that this federal election interference case won't go to trial before the November election. And then, if Trump wins in November, he could, in theory, pardon himself because it's a federal case. So whatever the Supreme Court decides could have very long impacts on future presidents, as well as very impactful outcome for Trump himself. So that happened on Thursday, very consequential. Also on Thursday, Harvey Weinstein's conviction in Manhattan was reversed by a higher court. He was actually convicted in the same courtroom in Manhattan where this trial against Trump is happening. Fun fact. Fun, if you can call it that. Anyway, so back to the Manhattan trial against Trump. Here's what happened on Thursday. Thursday morning, David Pecker was back on the stand and spent the whole day testifying. And I can tell you from experience, you got one witness on the stand testifying the whole day, that shit gets boring, okay? People are giving Trump a lot of shit for falling asleep during his own trial. I suppose if I were the criminal defendant on trial, I would probably be a little bit more on the edge of my seat, but this shit gets boring, y'all, okay? Not to defend Trump, but yeah, things get long. But David Pecker provided a lot of helpful testimony for the prosecution. They started back off on the Karen McDougal story. Pecker testified that he spoke with Trump directly about the story and advised Trump to buy her out because Pecker believed that the story was true and that it would damage Trump's campaign if it was released to the public. Pecker also testified that he believed Trump exercised strict control over Michael Cohen's use of funds, saying that every time he went out to lunch with Michael Cohen, Pecker paid, indicating that any money Cohen did spend on behalf of Trump had to be approved by Trump first. And so if he's spending money to pay off Stormy Daniels, then in this situation, it's likely Trump would have known about it based on that testimony. Pecker then testified that he brokered a deal with Karen McDougal for $150,000 plus various writing jobs with his magazines in exchange for her silence. And he actually consulted a campaign finance attorney to make sure that the contract was ironclad. But according to Pecker, the jobs that McDougal was given in exchange for the money, it was all just a cover-up so that it would seem like that's what she was getting paid for, the work that she was doing, when in reality it was money spent to keep her story secret so it didn't hurt Trump's campaign. And he said Trump knew about this $150,000 agreement. Pecker then said he hired an outside company to manage the invoice to Cohen to get paid back for the payments he made to McDougal so that those payments wouldn't be flagged in his own company's books and raise questions. So Pecker himself went to lengths to try to distance himself from this payment. Cohen never actually paid him back for that, though. Then the testimony turns to Stormy Daniels. Pecker testified that the night after the infamous grab him by the pussy Access Hollywood tape went public, Trump's team was scrambling, and it was discovered that Stormy Daniels was trying to sell her story as well. Pecker, however, refused to pay her off because Trump already owed him $30,000 for the illegitimate child story that he bought off and $150,000 for Karen McDougal, both of which remained unpaid. So Trump was $180,000 in the toilet with him, and he didn't want to shell out more money to keep her quiet. So basically, he told Cohen to shove it and pay her off himself if he wanted the story so bad. He also described an irate Trump calling him when the Wall Street Journal published the McDougal story 4 days ahead of the 2016 election. That McDougal story that Pecker had said he would keep quiet, it got published. Yeah, and Trump called him, and he was real mad, which indicates he knew about the agreement to keep her quiet. And then there were numerous meetings with Trump after the election, including in July 2017, when Pecker was invited to the White House to thank him for helping the campaign, with Trump telling him ahead of time, "It's your dinner, Invite whoever you want. Yikes. And Trump repeatedly checked in with Pecker about McDougal. He mentioned McDougal whenever they saw each other, and Trump once again called Pecker irate when McDougal gave another interview, this time to Anderson Cooper on CNN. They also then, the prosecution went on with Pecker to review the non-prosecution agreement that American media had signed with prosecutors over the McDougal payments. And the company was fined $187,000 for that McDougal payment because it was a prohibited in-kind corporate contribution that violated campaign finance law. And that same investigation led to Cohen's prosecution and conviction. According to reporters in the courtroom, Pecker was calm, and he described conversations with Trump in very vivid detail, which brought the case to life. And apparently the jurors were held in rapt attention throughout his testimony, at least on Thursday. And then Thursday afternoon, the prosecution finished its direct examination of Pecker, and then it was the defense's turn to begin cross-examination. And this gives the defense the opportunity to question some of that testimony and to question his credibility, if applicable. So the defense questioned Pecker about how common these catch-and-kill schemes are, and Pecker admitted that it was common for the National Enquirer and American media to only publish about half the stories they buy, indicating that they often will buy stories and then never publish them. Pecker also testified that he had been helping Trump squelch negative publicity for many years before he ever campaigned for president. And then after that, the defense peppered Pecker with questions about his ability to recollect things accurately, because they were attempting to undermine his credibility. And then court wrapped for the day around 3 p.m. on Thursday. Then Friday rolls around. We're at the end of the week already. How'd that happen? Here we are. So Friday morning begins with further cross-examination of David Pecker, and some reporters in the courtroom say the energy was low and everyone seemed fatigued after days of testimony, and it's the same guy day after day. Like I said, boring. The defense attorney went on a series of questions that some reporters in the room said were kind of confusing, hard to follow, not really sure what he was trying to get at. But he questioned Pecker on the National Enquirer's habit of publishing negative stories about politicians and reusing news from other sources, seeming to indicate that the publication regularly published negative stories about politicians, and it wasn't necessarily part of a scheme to influence the election, like this was common practice. And the back and forth in the courtroom Friday morning apparently dragged on and got quite in the weeds, and a lot of people in the courtroom were kind of just watching the minutes drag by until lunch. And during cross-exam this day, Pecker did admit that his publications did run stories written or at least ghostwritten by McDougal, indicating that American media did hold up its end of the bargain with that $150,000 payment. Like, she actually did do work. It wasn't just like, we're saying that you're going to do work, but really this is a cover-up payment. So this points out an important contradiction. Was the agreement with her just a cover-up to get her to stay quiet, or was it actually ironclad and just compensating her for her work? And it can maybe in actuality be both, but legally it has to be one or the other. Was it just a cover-up, or did each side actually perform its end of the bargain, making this a payment not to influence an election, but instead for work rendered? The defense also questioned Pecker's motivation for signing the non-prosecution agreement, indicating that his actions both in publishing or not publishing stories and in agreeing to cooperate were personally and financially motivated, not motivated by an intent to influence the election. Again, they just need to poke enough holes that at least one juror doubts whether or not there was intent to cover up an illegal scheme as part of this business records case. And then on redirect, so we got prosecution gets to question, defense gets to cross-exam, and then prosecution gets to come back and do redirect. The prosecution sought to remind the jury of what was actually written in that non-prosecution agreement. And what was written in it was, and I quote, "AMI's principal purpose in entering into the agreement with McDougal was to suppress the model's story so as to prevent it from influencing the election. At no time during the negotiation for or acquisition of the model's story did AMI intend to publish the story or disseminate information about it publicly." Pecker said AMI agreed to provide coverage of McDougal in its magazines basically as a disguise of the actual purpose. The actual purpose was to acquire her lifetime rights to the story so that it's not published. So again, they're just reinforcing the idea that, no, here's what's actually written. This was a scheme to influence the election, full stop. And a lot of the cross-examination on Friday was simply meant to nitpick Pecker's testimony, which overall was pretty favorable for the prosecution because he came across pretty amiable and likable according to reporters in the room. Then around 2:30 on Friday afternoon, Pecker finally finished his testimony. And the prosecution quickly moved to its next witness, and this is when things started to pick up a little bit. So their next witness was Rona Graff, Trump's longtime assistant. She testified that she was Trump's assistant for 34 years. Can you fucking imagine? And that she became senior vice president within the Trump organization, which would give her a lot of direct access to the inner workings of the organization. And she testified that she had access to Trump's contact list, and in that contact list were both Karen McDougal and Stormy Daniels, women who claim to have had affairs with Trump that he denies. So the fact that they're in his contact list, while not proving the affairs, does show that he at least knew them well enough to keep him in his contacts. Stormy Daniels, whose government name is Stephanie Clifford, was just listed as Stormy along with her cell phone number. So, while on direct examination, Graff said that she had seen Stormy Daniels at Trump Tower, but on cross-exam, she said that she did see Stormy Daniels at Trump Tower, but she assumed that Stormy was there to audition for The Apprentice. Graff also, shockingly, spoke very highly of working for Trump and has frequently spoken very highly of working for Trump, which, like, honey, blink twice if you need help. You know what I mean? Yikes. Graff's testimony was very brief, and then Friday afternoon saw the prosecution call its third witness, a man named Gary Faro, who previously worked at First Republic Bank, where he dealt with Michael Cohen directly. And Faro, as a bank official, was there to introduce some records into evidence. So when you want the jury to see an official business record, you can't just say, like, hey, jury, look at this. You have to have a witness there to introduce it to the jury, and that witness often, depending on the document, needs to certify the document, meaning confirm that it was accurate and kept in the course of doing business. And that's why Graff was there, and that's why they called Faro as well. And so Faro testified that Cohen always seemed frantic in his interactions at the bank, and that Cohen had opened multiple accounts for multiple new businesses, which the prosecution alleges were meant to hide the payments to Stormy Daniels. And then as Faro wrapped up his testimony for the day on Friday, he confirmed that Cohen opened an account for a new LLC called Essential Consultants LLC, from which Cohen would later pay Stormy Daniels her hush money payments. And then court wrapped at around 4:30 on Friday afternoon. And that's the end of Trump trial week 2. And that's where we stand. We're on the third witness for the prosecution, the end of the second week of trial. There will be no court on Monday, so the trial will resume Tuesday. And looking ahead, analysts are expecting the prosecution to lay the foundation for the hush money payments to Stormy Daniels through Pecker's testimony that we've heard and others to show the larger scheme meant to influence the outcome of the election. And they're then going to call Michael Cohen as their star witness, whose testimony will have already been corroborated by the testimony and documents before his testimony to try to make up for, that pesky perjury conviction. And then they'll end their case with a few more witnesses to further corroborate his testimony and drive their argument home. Then it will be the defense's turn to present its case, if any, and prosecution will have the opportunity to then present its rebuttal. And then the case will be handed to the jurors. And it is expected that the trial will take up to 6 to 8 weeks, and it could last into June. So that's where we're at. I have even more analysis of this in my Patreon community, which is linked in the description below. And you can join me next weekend for a recap of week 3's proceedings in the Trump trial, the first trial of a U.S. president in history. Thanks so much for watching. I hope you have a great day. Bye-bye.